Bueno, damos inicio entonces ahora a un inicio formal. Mi nombre es Brenda Luciana Maffei, soy responsable del área jurídica del Tribunal. Lamentablemente el secretario Juan Manuel no va a poder presenciar este evento por una cuestión de salud, ni hoy ni mañana, pero me dijo que iba a estar ahí viendo si aparece de alguna forma. Pero bueno, lamentablemente no va a poder participar. Fue un imprevisto de último momento. El fin de semana nos comunicó esto y bueno, tratamos de organizarnos entre nosotros para que el seminario pudiera realizarse, ¿sí? Así que bueno, hoy tenemos una mañana de actividades, tenemos 2 charlas. Juan Manuel me dejó un texto para que yo pudiera leerle a los participantes sobre la importancia que tiene esta actividad y dejar expuesto también su pensamiento, ya que él no puede hacerlo de forma presencial. Así que les voy a leer una partecita de lo que él escribió. Bueno, dice que cada vez más los proyectos de construcción se vuelven más complejos, dado que involucran aspectos no solo relativos a las cuestiones técnicas, infraestructura, minería, recursos naturales, etcétera, sino que abarcan temas ambientales y su impacto, relacionamiento con las comunidades donde opera el proyecto. Esto hace que los mecanismos de solución de disputas deban seleccionarse con cuidado, desde el litigio, el arbitraje, el manejo de riesgos, sistemas de alertas tempranas, hasta las juntas de resolución de disputas o dispute boards, donde no solo abogados, sino ingenieros y arquitectos intervienen. Es por ello que es interesante ver aspectos como el reclamo, que en esos casos se generan, y si el arbitraje es un medio idóneo para solucionar estas controversias que puedan llegar a surgir. Hoy tenemos dos charlas, ¿sí? La primera es de Julian Bailey, ¿sí? Y él va a hablar sobre Delay Claims in International Construction Arbitration. Voy a hacer una breve presentación sobre Julian. Julian Bailey is a partner in the London office of White & Case LLP, practicing in the firm's International Arbitration and Construction and Engineering groups. He advises on international construction and infrastructure projects across a variety of industries, including transport, oil and gas power, including renewables, petrochemical, process plant, industrial, retail, residential, tourism, healthcare, mining, marine, insurance, and defense. Julian has been active in relation to projects on most continents, representing sovereign governments, developers, and contractors in large construction and engineering projects and disputes. Julian is actively involved in construction law issues and was chairman of a Society of Construction Law, the leading industry body of construction law. He's also the author of Construction Law, one of the leading books on construction law. He's a visiting fellow in the Dixon Pond School of Law, King's College, London, an adjunct professor of law at Hamad bin Khalifa University in Doha. So, Julian, there. Sorry for my English. My English is not well done, but
English is great, and thanks very much
for
having me here. Hola and bonjour, as I think you say in South America. It's great to be here. I'm in London, and you're far away. I wish we could all be together, but that's how things go. I'm going to try to share my screen. Let's see if this works. Oh, can I please share? It says I need your permission to share my screen. So maybe if I can be given permission, that would be great. I just have a few slides that will hopefully be of interest. This might work, I hope. Let's try it. Okay, how's that looking? Can you see that?
Yes.
Great. Okay, that's a miracle. I've got the technology to work. Okay, well, what am I going to be talking about today? I'm talking about delay claims in international construction arbitration. And I have a little structure here, although it's not really much of a structure. I'll start with an introduction to the topic, and then I'll introduce a factual scenario for us to consider, because I think it's often helpful if we consider construction problems with reference to actual projects as opposed to talking about things in the abstract. Then we'll look at some of the legal aspects of delay claims and how they work under construction contracts. And then we'll come to international arbitration and how delay claims are dealt with in international arbitration. So where do we start? Well, I think we can start by looking at the varying speeds at which construction projects can take place. And this is a slide from a news story that caught my eye a while ago. See, the Chinese are building a 57-story skyscraper in 19 days, which sounds absolutely incredible in terms of speed. So that's building fast, and there's no real issue there about delay as such, as you can imagine. But then we've got at the other end of the spectrum, building a bit more slowly. So this cathedral will be familiar to many of you. It's in Barcelona, of course. It's the Church of the Holy Family. And it was started in 1882. And it may be that it is actually finished in 2026, but who knows? Maybe even that will be an underestimate for how long it's going to take. So some building work can take a long time, and delay is quite an issue in construction and engineering projects, as many of us know. The question is just how common is this? And to give you a snapshot of this, here's a little news story I gathered a while ago, which I think is representative, really. So this is from a UK architects journal, where the headline says it all. Almost 2/3 of projects were late in the past 12 months. So that tells us that many projects, in fact, most projects, may indeed finish later than they're meant to. So delay is a very common thing, which is why we see it a lot in construction and engineering disputes. And if we're asking, what are the causes of delay? Why do projects take longer than they should? There is some information about this, and it's fairly recent information too. So there's a body in the United Kingdom called RIBA, which is the Royal Institute of British Architects, and they conducted a survey and published a report a few weeks ago, and they asked people lots of questions. And one of the questions they asked was, during the construction phase of the project, which if any of the following matters impeded project progress during the past 12 months? And you can see hopefully on this slide that some of the more popular causes of delay include employer's variation. So the employer changed something, that's something to do with the employer. But if we look at number two, it's COVID. That's a newcomer to causes of delay, but that's obviously had a big impact. And contractual responsibility for COVID could be either with the employer or the contractor, depending on the contract. The third one is required construction products not being available. And this is still a problem in the world, as we know, with global supply chain issues and getting products that people need. That's been a big cause of delay. And again, the contractual risk of that can be with either the employer or the contractor. But the next item is something which is purely a risk which a contractor takes, which is the slow pace of construction. The contractor was running late itself. So those are some of the causes, the main causes of delay. But the thing to note about them is just running through the top four there, you can see that as a matter of legal risk, the risk is not only with one party. It could be a neutral risk in the sense that it could be with one party or the other, or it could be an employer's risk or a contractor's risk. And when you have projects being delayed by a combination of these causes, it can give rise to disputes about, well, which cause was really leading the project to be in delay. And this is one of the underlying issues or problems with construction and engineering disputes over delay, because there is often a forensic issue about what was causing the delay to the project. So to try to bring some of that to light and to see how it might work in practice, I've come up with a hypothetical factual scenario which I think teases out some of the potential issues. So let's imagine we've got a project which is in this the fictional country of Perivia, which is somewhere in South America, and is a project to construct a 25-kilometer road segment, which includes 2 kilometers of tunnel. And I've supposed in this example that the contract which is used is a FIDIC pink book, as it's called, which is the MDB harmonized version. This is a popular form of contract, which is used where international development funding is used in particular. So that's the project. Now, what happens? Let's assume that the contract's entered into on the 1st of November 2019, and the contract's agreed to be subject to English law. The time for completion is 24 months, so 2 years, meaning the work has to be finished by the 1st of November 2021. Contract price is $100 million US, and there are liquidated damages payable for contractor delay. So if the contractor is running late, the contractor has to pay $100,000 per day, up to 10% of the contract price, so up to $10 million. So that's the contractual setup, and the contract signed, the work starts. And the first lot of work the contractor does is in relation to the tunnel, and it starts rock blasting in the tunnel, and that's initially looking good. But however, a problem is discovered because in late February, it's realized that the contractor was actually doing the blasting work in the wrong spot. So it has to realign the excavation and the blasting and do it in a different area. And this is all the contractor's fault. It was its own mistake, and it's going to cause, it's predicted to cause 2 months of delay to these tunneling works. So that's one delay that's cropped up. And that was February 2020 when that problem was discovered. But then shortly thereafter, another problem comes along, something we're all familiar with. COVID appears in Perivia. And when COVID appears, the government of Perivia passes laws relating to social distancing and stopping the travel of people and goods moving around. And initially, all construction sites are shut in March, but then they're allowed to reopen in early May. So 2 months later, they can reopen. But social distancing needs to be followed in the workplace here. And let's suppose the contractor estimates that there's going to be a 3-month delay in completing the work because of the COVID issue. And the whole project is affected, not just the tunnel, the whole 25 kilometers of the project. So the contractor claims under the contract and a 3-month extension of time because COVID has appeared. And it says, well, I need more time under this contract. I'm entitled to more time because of this particular issue. But the engineer, who's the person assessing the extension of time claim, as we'll see in a moment, rejects the claim, saying, no, the cause of your delay is the problems with the tunnel, and they're your fault. So what then happens? Well, the project goes on, it finishes, but it finishes on the 1st of January 2022. So it's 2 months late because the project was meant to finish on the 1st of November 2021. Now the employer says the project is late because of the contractor, because of this issue with the tunnel being in the wrong spot initially. And so no extension of time was awarded to the contractor. So the employer says, I'm entitled to claim liquidated damages for the period of delay, which was 61 days. So the employer says 61 days, $100,000 a day is $6.1 million. That's what the employer is claiming from the contractor. And the contractor disputes this and says, no, that's not right, because I was delayed by the COVID situation. That was the real cause of delay here to the project. And I therefore should have been awarded an extension of time under the contract, which wrongfully was not awarded to me. And had that been done, liquidated damages would not be payable. So that's the scenario. That then takes us into how this is all dealt with as a matter of law, certainly as a matter of English law applied to this contract. And if we step back and look at things from an English law perspective, asking the question, who takes the risk of delay? At the highest level, the highest conceptual level, the answer that we give is that it's up to the parties to decide and agree in the contract who takes the risk. English law applies this notion quite strongly of freedom of contract, so that if you have competent people who can enter into a contract, they can agree to the terms of their choosing, and the courts or arbitrators will apply those terms. That's the key here. So we start and we finish really by looking at what the contract says about extensions of time. And in this particular form of contract, the FIDIC form of contract, the relevant extension of time clause is subclause 8.4, which I've set out here on the slide. And you can see here from the wording that it says that the contractor shall be entitled, subject to clause 20.1, to an extension of the time for completion, if and to the extent that completion for the purposes of 10.1 is or will be delayed by any of the following causes. And we have a number of causes listed out here, including variations, exceptionally adverse climatic conditions. But the provision that's most relevant to us is in subclause D, which is unforeseeable shortages in the availability of personnel or goods caused by epidemic or governmental actions. And the contractor says, well, when COVID came along, the government of Perugia passed all these laws relating to COVID, and this caused me to suffer a shortage of personnel and goods, and that led me to be in delay. So this is a cause of delay to the project, which entitles me to an extension of time. So that's potentially a good thing for a contractor in this situation, because it has a contractual right, which is an agreed right to an extension of time. And how are extensions of time dealt with under this particular contract? And most construction and engineering contracts will typically, that they allow for the contractor to claim an extension of time, and then for someone to assess that extension of time. And in this case, it's the engineer under the contract. And so you can see here that at the bottom of the slide, it says if the contractor considers himself to be entitled to an extension of time, the contractor shall give notice to the engineer in accordance with subclause 20.1. And what happens then is that the engineer is to make a determination about the contractor's entitlement or not to an extension of time. But the thing I want to draw your attention to, and this is typical of quite a number of contracts, is that the mechanism in the contract for assessing extensions of time is actually not very prescriptive at all. So the relevant provision is actually subclause 3.5, which is concerned with determinations by the engineer, which is the relevant provision to extension of time claims. So subclause 3.5 says, among other things, that when the engineer is required to make a determination, the engineer is to try to get the parties to agree upon the matter by consulting with them. And if that fails, and this is where the last sentence is relevant, which I've highlighted, it says, if agreement is not achieved, the engineer shall make a fair determination in accordance with the contract, taking due regard of all relevant circumstances. So that's what the engineer has to do, make a fair determination. And you might ask, well, what is a fair determination in this case or in any case? And English law is not very prescriptive about, or precise even about what a fair determination is, but certain ideas emerge from the law as to what constitutes a fair determination. And what it means, I suggest, is that at the very least, the engineer, when assessing the claim, has to do his or her best on the available material, on the facts as presented to the engineer at the time. And the engineer needs to do this acting in good faith. Now, it may be that if the contractor has not given much information about its extension of time claim, the engineer should request that further information in order to make a fair determination. The engineer needs to act in a professional way in assessing the claim. But what flows from all of this is that if the contractor fails to provide the information, maybe it doesn't have the relevant records that the engineer is after, but it's clear that it has a valid basis for claiming an extension of time, what the engineer must do is do his or her best and award what is an appropriate extension of time in the circumstance. The engineer can't simply reject the claim and say you have no extension of time if there's clearly a basis for the contractor claiming that extension. And provisions of this nature, which refer to a fair and reasonable extension of time being granted, have been used in construction and engineering contracts for a very long time. Certainly the English forms of contract, which are quite influential internationally. And we need to ask why that is the case. Now, if you look at this slide, this might seem like a strange sort of slide that I'm using here. There's a fellow there holding a gun, and there's a target. Well, I'll explain why I've done that. So the fellow holding the gun was a lieutenant general in the Soviet army, and he invented, his name was Lieutenant General Mikhail Kalashnikov, and he's holding the gun which he invented, the Kalashnikov, the very famous rifle. And to explain why I'm mentioning any of this, we need to understand the history of this gun and how it came about. So at the end of the Second World War, the Soviet army realized that the Germans had better guns than them. So they had a competition in the army for who could come up with a new gun for Soviet soldiers, and they had a competition. And it was won by Kalashnikov. Now, the thing about Kalashnikov's gun versus the other guns was the other guns were actually more accurate, so they could hit the bullseye quite often, whereas Kalashnikov's would maybe hit the target but sort of spray around the 10 and maybe hit the 6 or the 5 or the 4 and so on. So it wasn't the most accurate of guns, and there were more accurate guns, but they went for his gun. And the reason they went for the Kalashnikov rifle, the Soviet army, was because it could consistently hit the target in the field. So it could withstand all sorts of conditions: dust, dirt, snow, heat, etc. It would function. It was simple and easy to use, and it was useful by the people who needed it most, the soldiers in the field. Whereas the other guns, which are more accurate, would in fact seize up and not function at all in the field if they got dust or dirt in them. So the reason for referring to the Kalashnikov is to understand that its success comes down to not its accuracy, but its flexibility and the ability to use it in the field. And that's true of these non-prescriptive extension of time clauses, clauses that don't say how an EOT is to be determined, that say there shall be a fair and reasonable EOT. What this is telling us is that the engineer, when assessing the EOT, doesn't have to come up with a precise assessment. The engineer just has to make sure that an EOT is awarded where appropriate, and the EOT hits the target. It's in the ballpark of what the contractor should be given. And that lack of precision, I suggest, is actually reflected in not only in construction contracts and extension of time clauses, but in how, in legal cases, historically at least, extension of time claims have been determined. The subheading I have here is how EOT disputes were resolved in the good old days. Well, about 100 years ago, even less, disputes over delay were not resolved with very precise evidence at all, or methodology. And to illustrate that, I'm referring to a case from 1915, it's Matsoukas and Priestman, which is an English case. And this is a case about a contract to build a ship. And the contract said that the ship had to be delivered by the 28th of February, 1913. The contract included an extension of time clause, saying the shipbuilder could have an extension of time for various things, including workers' strikes. And what happened in the United Kingdom was there was a national coal strike in 1912, which caused delay to the works at this particular shipyard. And so an extension of time was claimed by the shipbuilder. How was this addressed in the court process? Well, the issue was put before a jury. So a jury of 12 people decided what extension of time the contractor, or the shipbuilder, was entitled to. And as the court said, the jury found in respect of the delay caused by the strike, the defendants, that's the shipbuilders, would be entitled to an allowance of 70 days. And the jury didn't have to give any reasons for its decisions. It just gave a decision based on fairly unscientific evidence. But that worked. That resolved the issue over the extension of time entitlement. Now, if we fast forward from there to the present day, delay evidence and the way that delay evidence is addressed in court cases and arbitration cases is very, very different. It involves a lot of computer software. It involves going into detailed records and programs. So it's a very different kind of a beast, particularly in international arbitration. And the matter is complicated even further because what we often see in construction and engineering cases increasingly is there being disputes and issues over overlapping causes of delay, whether they're called concurrent or parallel delays. How could that arise? Well, you could have two delays, one of which is the employer's risk, like the COVID issues in the example that we referred to, and the other is the contractor's risk, such as the error the contractor made in deciding where the tunnel would go. And if these risks come to bear and the delays apply at around the same time, you can have real issues about, well, what was actually causing the delay to the particular project. And there's a question about how these concurrent or parallel delays affect a contractor's entitlement to an extension of time. And the answer that English law gives is not particularly clear. And in fact, some of the commentary that we see in relation to English construction law gives out certain messages which may not be reflective of the law itself. So I've got a quote here from, this is the Society of Construction Law Delay and Disruption Protocol. The second edition comes from 2017. This gives some guidance, and it's just guidance, it's not the law, on how extension of time should be dealt with where there is concurrent delay. And I won't read it out, but I'll just focus on the last sentence, which says, where contractor delay to completion occurs or has an effect concurrently with employer delay to completion, the contractor's concurrent delay should not reduce any EOT due. Now, what that is essentially saying is that if you have a contractor delay and an employer delay, which apply at the same time, you can basically ignore the employer delay for the purposes of working out the contractor's EOT entitlement, which is a possibility in terms of how an EOT is assessed. But I suggest it's not actually a requirement, particularly under EOT clauses in contracts, which provide for there being a fair and reasonable extension of time, taking into account all the relevant circumstances. And that, I think, is consistent with an engineer saying, well, okay, the employer was in delay, the contractor was in delay at the same time. Maybe there can be some kind of apportionment of the delay between the parties. So the contractor might get, let's say, a 1 month extension of time if it's claiming a 2 month extension of time. So there's a lot going on in relation to these particular issues, these complicated issues in English law and in construction and engineering arbitrations, which leads us now to international arbitration and how these delay claims are dealt with in international arbitration, because it's actually not, there isn't a simple way of dealing with these claims. The evidence presented in construction cases concerning delay is often very fact heavy. There can be references to lots of meeting minutes, letters, emails, etc., programs as part of the overall evidence of each party. And so there's a lot to deal with, and computer software is heavily used. And we now have, and have had for a few decades now, specialist expert witnesses who deal just with delay issues and help courts and tribunals try to understand what was the real cause of delay to a project, because that can be such a messy issue. And the common format in which evidence is given in international construction arbitrations involves each party appointing their own individual delay expert, and those delay experts will prepare the individual reports on the causes of delay to the project. And then commonly the tribunal will direct the experts to prepare joint reports to go into the arbitration. But even then, this might sound methodically straightforward, but it's very complicated too, because there are a number of different techniques for analyzing delay, which experts can use, and which can lead to vastly different results. I've set out here on this slide a summary from the SCL delay and disruption protocol of some of the particular techniques that can be used. But the upshot is that you can have, and I often do see, quite polarized delay expert evidence in international arbitration. So if we come back to our little example where the project was delayed by 2 months, you may well have the contractor's expert evidence, which goes into great detail, but ultimately concluding the project was delayed by COVID issues. But then you could have the employer's delay expert producing, again, a detailed report, but showing, using accepted analytical techniques, that the delay was predominantly caused by the error in excavating the tunnel. So you might ask, well, how can you get two experts looking at the same set of facts coming to completely opposite conclusions on causes of delay? Well, that's actually one of the big issues at the moment for people who work in international construction arbitrations. I'm not sure there's a simple way of overcoming these issues, but I conclude by giving a suggestion that maybe we could simplify things by going back to the good old days when we had a jury, and the jury could answer the question in fairly short order with no reasons to be given. So I'll conclude there. Thank you very much.
Congrats. It was awesome, Mr. Julian.
Okay. Thank you. Thank you very much, Julian. Yes, sir.
Senhora Karina, será aberto para perguntas ou discussões?
We have a question from Juan Manuel in the chat.
Yes, sure.
So, okay. Juan Manuel said, in your experience in those arbitration proceedings, what is the applicable law to the case, and is international law applicable? I mean, public international law, private international law, or a non-state law?
Yes, in construction and engineering disputes like the one that I was referring to in my example, so we're talking about private international law, because usually these are contracts which are of a private commercial character. There could be some possibility that public international law applies where you have governments entering into contracts, but that's probably less likely for commercial arbitration. So the answer is private international law.
Okay, thank you very much. Luis, ¿tienes alguna comment or remark or something like that? Yes.
Good afternoon, Professor, and thank you very much for your presentation. I think we have a great advices and material here. So I have a few questions for you. And in your experience, how can we avoid this kind of problems and common problems? Can we, by using dispute boards, avoid this kind of problems and treat all this kind of problems and with this method? And I want to know if how can we be like legally cover it and in the time we contract in this material in this matter.
No, thank you, Luis. That's a good question, and the question we always ask is, how can we avoid the situation from arising? How can we make sure that projects finish on time, they're not running late? And I think that there's no simple solution here for this kind of problem. Dispute boards can help in resolving disputes before they become big arbitrations, but I don't think they can really stop the underlying problems from arising when we're talking about projects running late. A project will run late irrespective of whether you have a dispute board or not. And if a project does run late, then you can naturally have issues about who was responsible for the project running late. So as I said in my concluding slides, I don't think there is a simple solution here, unfortunately.
Thank you very much.
Si alguien quiere hacer otra pregunta, también queda dado el micrófono de los asistentes para realizar una pregunta. Pueden levantar la mano también si quieren, y ahí los habilito el micrófono. ¿No? ¿Nada? Entonces, con las presentaciones del día de hoy, nuestra siguiente expositora es Karina Zambrano, que va a hablar sobre el arbitraje como medio más idóneo para las disputas. Karina es árbitra conciliadora, capacitadora, experta en solución de conflictos con el Estado y gestión pública, fundadora del Centro de Arbitraje, Centro de Capacitación de Asociación Zambrano y del Centro de Conciliación Solución, directora del capítulo peruano de la Red Latinoamericana de Abastecimiento RLA. Karina, muchas gracias por tu presencia y bueno, quedas abierta a la exposición.
Gracias, querida, ¿cómo estás? No te preocupes, yo también me asusté cuando escuché a Jan y dije, oh, la conferencia va a ser en inglés. No, va a ser en español y vamos a conversar ahora en español. Felicito a nuestro expositor anterior y estoy de acuerdo con él en que la solución de las controversias deben ser justas y razonables. Asimismo, quiero, antes de empezar con la ponencia, agradecer al Tribunal Permanente de Revisión del Mercosur y el Tribunal Permanente de Revisión del Mercosur. Es un honor para mí estar presente el día de hoy. Y bueno, y agradecer a Juan Manuel Rivero Godoy por todas las gestiones realizadas, la invitación y al comité organizador. Está quedando muy bien el evento y muchísimas gracias y felicitaciones. Bueno, les cuento un poquito de mi experiencia. Yo soy árbitra en el Perú, bueno, efectivamente hace más de 20 años. Y empecé primero siendo abogada, antes de tener el título ya era conciliadora, que ustedes conocen como mediación. Después me dediqué a resolver conflictos mediante arbitraje. Ahora estoy en la lista principal de árbitros del Estado, ¿no? Y bueno, y actualmente resuelvo controversias como adjudicadora o dispute board. Entonces, quería contarles, en el caso de Perú, es el único país en el mundo que los mecanismos alternativos son obligatorios, ¿ok? Para resolver controversias privadas y con el Estado. Por ejemplo, para un contrato en el cual una de las partes sea el Estado, es decir, Poder Ejecutivo, Legislativo, Judicial, u organismos constitucionales autónomos, y la otra parte es una empresa privada o persona natural o jurídica, las controversias no las resuelve el Poder Judicial, las resuelve los árbitros. Y eso se llaman los arbitrajes con el Estado. Entonces, no es competente el Poder Judicial, la mayoría de las reclamaciones las resuelven los árbitros, y ha generado una especie de especialidad de más de 500 árbitros que resuelven más de 100, 200 controversias, e incluso 500 controversias anuales. Y nuestra ley de arbitraje, la ley de arbitraje peruana, es una de las mejores en el mundo. Entonces, la especialidad que hemos tenido los árbitros por resolver la cantidad de controversias sobre temas del Estado ha hecho de que este producto se venda al extranjero y muchos países estén interesados en incorporar en sus normas este tipo de arbitraje. En cuanto, por ejemplo, a la Junta de Resolución de Disputas o Dispute Board que ustedes conocen, desde hace 2 años, a partir de la modificatoria de la ley de contrataciones, es obligatorio también resolverlo mediante la Junta de Resolución de Disputas o Dispute Board, los contratos de construcción mayores a 20 millones. Entonces es necesario que esté un panel conformado por un ingeniero o 2 ingenieros y un abogado. Entonces es obligatorio. También ahí no es competente el Poder Judicial y las decisiones se tienen que respetar hasta que termine la obra. Lo que está dando un mayor resultado, es decir, 100% de ejecución y cero controversias y 0 arbitrajes. El otro mecanismo alternativo que ustedes conocen es la mediación, en el Perú se llama la conciliación. Para interponer una demanda al Poder Judicial sobre obligación de dar, sumas de dinero, etc., es necesario que las partes primero acudan a un centro de conciliación. En el centro de conciliación, si llegan a un acuerdo, se levanta un acta que tiene el mismo valor que una sentencia consentida y ejecutoriada de calidad de cosa juzgada. Se llama el acta de conciliación. Y en caso de incumplimiento, esta solo se ejecuta. Si no llegan las partes a un acuerdo, este es el requisito para que se pueda interponer una demanda. De no pasar primero por un centro de conciliación, debidamente autorizado por el Ministerio de Justicia, las partes no pueden ir al Poder Judicial, no pueden ir a litigar. Entonces, esta obligatoriedad en los mecanismos ha generado un boom desde hace 15 años en el Perú, en el cual las controversias se están resolviendo, ya sea por arbitraje, por conciliación o por Junta de Resolución de Disputas, o Dispute Board, como conocen en el extranjero. Esto genera un grado de satisfacción mayor en la resolución de controversias. El día de hoy me toca exponer sobre si el arbitraje es el medio más idóneo para resolver las controversias. Tengo que convencer a la audiencia por qué debemos elegir al arbitraje como el medio más idóneo. En este sentido, después de darles esta introducción, quisiera compartirles un poco el PowerPoint que he preparado. Si me permites compartir pantalla.
Creo que ya podrías, porque puse que pueden compartir.
Entonces, después de haberles dado esta linda introducción, voy a abocarme el día de hoy a la ponencia. Y bueno, sí, efectivamente, puedo concluir, darles ya la lista de afirmación, de que el arbitraje es el medio más idóneo para resolver las disputas. De repente no podemos competir con los dispute board, o quizás con la conciliación, porque estos medios son más eficientes, son mucho más rápidos. Muchos dicen que el arbitraje es un medio que se utiliza post-mortem, es decir, después de haber ocurrido las cosas. Porque efectivamente los dispute boards son mecanismos que se utilizan en la misma obra, en la misma construcción. Los adjudicadores van resolviendo las controversias que se presentan en el día a día. En cambio, los árbitros ya resolvemos cuando ha finalizado prácticamente el calor, el ardor de la controversia, pero todavía existe una controversia. Voy a demostrarles en el transcurso de esta exposición el por qué el arbitraje es importante para resolver las controversias, a pesar de que es un mecanismo posterior y no utilizado inmediatamente en la solución de controversias. Como todos sabemos, el arbitraje es un mecanismo heterocompositivo, un método heterocompositivo que tiene por objetivo resolver controversias de forma alterna al Poder Judicial. Los procedimientos en el arbitraje son rápidos y flexibles y se acomodan a las necesidades de las partes. Puedes resolver una controversia en un día o en 6 meses o 12 meses, depende de la voluntad de las partes y la agilidad del tercero, del árbitro. Las decisiones de los árbitros tienen un valor en la sentencia y calidad de cosa juzgada, es decir, son inimpugnables, salvo el recurso de anulación que se presenta por afectación al debido proceso. Efectivamente, las partes recurren al arbitraje, los inversionistas, por la poca credibilidad de los tribunales de justicia en el mundo. Sabemos que los tribunales tienen un grado de aceptación de 8, 9, 10% en el mejor de los casos. Lo mismo pasa en el caso peruano y en los demás países en el mundo. Puedo elegir 7 razones por las cuales podemos elegir al arbitraje como el mecanismo más idóneo. Primero es la elección de los árbitros. La segunda es la independencia y parcialidad de los árbitros. El principio competence, la celeridad en los procesos, la predictibilidad, la confidencialidad y la cosa justa. En cuanto a la elección de los árbitros, cuando nosotros elegimos como forma para resolver el conflicto del Poder Judicial, no tenemos elección del juez, porque esto se determinará en base a la competencia. En cambio, si nosotros vamos a un arbitraje, podemos elegir a nuestro árbitro. Podemos googlear a nuestro árbitro. ¿Quién es el árbitro? ¿Cuál es su posición frente a una controversia? ¿Cuál es su trayectoria? Y de tal manera que nosotros elegimos de acuerdo a las necesidades de la controversia. Entonces, en ese sentido, el arbitraje permite desde el inicio tener la elección de un tercero especializado. En cambio, el juez no puede conocer todas las materias y efectivamente eso genera cierto detrimento en la resolución de la controversia. En cambio, el árbitro tiene que ser especializado en la materia por el cual se le elige. El otro tema es la independencia e imparcialidad de los árbitros. El árbitro, nosotros sabemos que en los poderes judiciales la independencia e imparcialidad no necesariamente es una garantía que predomina en la jurisdicción común. A veces se resuelve en base a intereses, se resuelve en base a quién tiene más dinero, porque contratas un abogado, la prueba es tasada. En cambio, en el arbitraje, los árbitros necesariamente deben contar con la garantía de independencia. Por más que tú lo has elegido, el árbitro en ese momento, el que tú has aceptado, ya no representa, representa, ni menos es un asesor a los intereses de quien lo ha elegido. El árbitro se convierte en el momento de la aceptación un juez independiente. Por lo tanto, la legitimidad de los árbitros permite su recomendación y elección. La actuación del árbitro va a determinar que las partes lo elijan para un segundo arbitraje, un siguiente arbitraje o no. Entonces, esto es muy importante porque los árbitros están en constante evaluación, en cambio, los jueces no. Otro tema importante por el cual debemos preferir el arbitraje es por el principio competence-competence. Una garantía, el principio que más me encanta en la ley de arbitraje es el principio competence-competence. Cuando se cuestiona la competencia de los jueces ordinarios, normalmente el juez renuncia a esta competencia y excepcionalmente decide continuar el proceso, generando incertidumbre en el proceso. En cambio, cuando se cuestiona la competencia de un árbitro, tiene la facultad de decidir acerca de su propia competencia. Y normalmente los árbitros se declaran competentes. Esto genera certidumbre, y esto en la práctica se materializa cuando una de las partes del convenio arbitral objeta o obsesiona el arbitraje, tratando de que sea inejecutable. A este efecto interpone la llamada excepción de incompetencia. En atención a ella, los árbitros se declararán competentes. El otro aspecto que me encanta de los arbitrajes es la celeridad en los procesos. En el Poder Judicial no tenemos certeza de cuánto tiempo durará un proceso. Reina la incertidumbre, siendo el promedio de 2 a 4 años. Es imposible pensar que un proceso judicial va a terminar en un día. Los arbitrajes sí. Yo he tenido casos en el cual las partes me dicen, doctora, tenemos una controversia, ya sabemos cuánto le vamos a pagar, solo nos ponemos de acuerdo el día de hoy sobre las reglas. En ese momento, dentro del proceso arbitral podemos mediar, ¿ok? Llegamos a un acuerdo y yo puedo homologar ese acuerdo a un laudo arbitral, el cual es perfectamente ejecutable. Entonces, depende de la agilidad del tercero para resolver la controversia, siempre y cuando exista voluntad de las partes. En cambio, en el arbitraje tenemos que las controversias se resuelven en un promedio entre 12 a 18 meses, en el caso peruano, siendo predecible el tiempo de duración de controversias gracias a la posibilidad de incorporar calendarios. O sea, podemos establecer cuáles son los calendarios que vamos a tener dentro del proceso arbitral estrictamente. Es más, en el Perú tenemos un procedimiento acelerado que dura 3 meses y me parece muy importante. En Panamá, recuerden, en los temas de laborales tienen un procedimiento de 2 meses. Entonces, existe realmente agilidad en los procesos, por lo cual depende del árbitro y de las partes resolver las controversias en menores tiempos. Otro tema, ¿por qué el arbitraje es idóneo? Es la predictibilidad. Las decisiones de los jueces y los tribunales ordinarios son lamentablemente impredecibles. Los plenos casatorios son insuficientes para crear jurisprudencia en todas las materias. En cambio, los arbitrajes son normalmente predecibles. La elección de los árbitros y conformación de los tribunales arbitrales determinan en gran parte la decisión. Quinto punto, y no menos importante, es la confidencialidad. En el Poder Judicial, la actuación de los órganos jurisdiccionales es pública por naturaleza. En cambio, en el arbitraje predomina la confidencialidad en el proceso. Permite que las partes puedan resolver sus controversias sin la intervención de terceros y evitar el impacto público, salvo el arbitraje con el Estado. Como les comentaba, en el Perú, los contratos con el Estado se resuelven mediante arbitraje, y eso sí necesariamente deben tener la información pública. Las partes deben acceder a cómo se ha resuelto, quiénes son los árbitros, el tiempo que ha durado, aunque todavía estamos en discusión si debe ser público o privado, porque todavía se mantiene la garantía de la confidencialidad. Finalmente, tengo que decirles de que los métodos alternativos de resolución de controversias, como el arbitraje, la mediación, los dispute board, que se utilizan en temas de construcción, no son excluyentes, son complementarios, son como una caja de herramientas. Es decir, el tercero tiene que conocer qué herramienta es necesaria para esta controversia. Quizás esta controversia es necesaria un arbitraje, quizás sea un dispute board, quizás en esta otra sea necesaria una mediación. Entonces, el tercero tiene que utilizar una herramienta para cada controversia. Quizás es necesaria una cláusula escalonada, primero una mediación, luego un dispute board, luego un arbitraje, o quizás todas. Entonces, en ese sentido, el tercero tiene que tener la agilidad para saber qué herramienta va a utilizar para cada controversia. Claro, teniendo en cuenta la normativa de cada país. Ahora, finalmente, otra garantía del arbitraje es la cosa juzgada. Lograr la cosa juzgada en las decisiones judiciales es casi imposible. Siempre existe otra vía que pueda amparar el derecho de los litigantes. La doble instancia permite que toda sentencia sea apelada y nuevamente se valore la prueba. En cambio, la decisión de los árbitros es inimpugnable, por ejemplo en el Perú, aunque en otros países sí todavía tiene la revisión. El laudo arbitral es definitivo e inapelable. La resolución de controversia se produce en única instancia. Y en caso de incumplimiento, solo procede el proceso de ejecución. Finalmente, les vuelvo a recordar que todos los mecanismos son complementarios. Depende del tercero utilizar el medio más idóneo para cada controversia. No pueden ser excluyentes. Y efectivamente los métodos, recuerden siempre que es como una caja de herramientas. Bueno, estoy muy contenta de haber participado en la ponencia. Muchas gracias por su atención. Estoy llana a las preguntas que me haga el panel el día de hoy. Muchas gracias.
Bueno, muchas gracias, Karina. Es muy interesante tu exposición. Tenemos ya una pregunta de Juan Manuel, que dice, pregunta que en tu experiencia, ¿cuándo es preferible el arbitraje y cuándo el dispute boards? Teniendo en cuenta sus diferencias.
Ok. Normalmente el dispute board es muy importante.
Karina, discúlpame, pero creo que tu cámara está apagada.
No.
Bueno, yo no te veo.
Ahora sí.
Sí,
Okay. Gracias. Bueno, efectivamente, ambos mecanismos son muy eficientes, pero en la práctica, para los temas de construcción es muy importante el dispute board, porque estás en obra, temas de adicionales, modificaciones, ampliaciones de plazo, está el panel en la obra, inmediatamente se hace la pregunta, convoca una reunión, emite una opinión, esta puede ser vinculante o no vinculante, depende del acuerdo de las partes. Entonces, por ejemplo, conozco el caso chileno de que grandes obras, a metros de distancia y profundidad, el panel tiene un cuaderno de obra electrónico, en el día el residente y supervisor llenan las ocurrencias, si hay una controversia se resuelve dentro de 24 horas, de tal manera que 100% de ejecución, 100% de ejecución de presupuesto de la obra y 0 arbitrajes. Entonces, para los temas de construcción, necesariamente el dispute board está dando muy buen resultado en el mundo y también en el Perú. Los temas de arbitraje, sobre todo lo utilizamos más para el tema de daños, de indemnización, temas de obligaciones de dar, suma de dinero, incumplimiento de contratos, temas de bienes, servicios, etc. Es muy efectivo el arbitraje porque tú tienes la capacidad de reducir los tiempos, depende de la necesidad de las partes. Recordemos que si una controversia no se resuelve en 3 meses, las partes, las empresas pueden quebrar. Entonces es muy importante que los arbitrajes sean más rápidos y flexibles.
Bueno, muchas gracias. Si alguien tiene alguna pregunta que no se anima a hacerla en el micrófono o poner la cámara y quiere hacerla en el chat, también está habilitado para que puedan escribirla y yo se la paso a Karina. Hoy es nuestra última expositora y mañana recuerden que empezamos también a las 10 horas de Paraguay. Tenemos 4 exposiciones más y va a ser un poquito más larga que hoy. Hoy ya estaríamos terminando, si no hay más consultas, preguntas, comentarios que quieran hacer. Ya estamos terminando la jornada de hoy. Así que bueno, parece que no hay. Ahí les dejé en el chat.
Ha quedado claro.
En el chat, si van un poquito a los que entraron después, si van un poquito más adelante, van a ver un formulario para completar para acceder al certificado. Mañana de todas formas lo voy a volver a poner. Así que bueno, muchas gracias. Juan Manuel, que te recuperes pronto, que ahí está viéndonos también. Así que bueno, seguimos mañana entonces.
Sí, Juan Manuel, recupérate. Abrazo y saludos a todos. Nos vemos
Chao,
pronto.
chao.
Muchas gracias.